Wait, now before you think now, let me go there now, boy.
Yeah, go ahead, man. Go ahead.
There will be a part of face. What do you have with the case? Don't put the camera on me.
Stand up on the edge there, not to block. Yeah, go down. Yeah, we could give the ladies the seat, and the men could stand up. The ladies get in the seat, and the men standing up. Okay, we turn on our cell phones, eh?
Someone check the cell phones, people. Check the cell phones, people are coming. On that side.
Just remember, we're about to start. Good morning. Good morning. Well, I must thank all of you for coming, and in particular, I would like to thank the members of the media at such short notice to come here this morning. I have invited the media to come here this morning because the judgment which has been given in the Privy Council has implications for the public interest. In that, you would have noticed from the judgment, the Privy Council stated that the police service, the Trinidad and Tobago Police Service, is a regulated police service, and therefore the Municipal Police Service should also be regulated. And therefore the failure over the years for regulations to have been made in important areas which affect pay, terms and conditions and promotions were very serious matters which can affect the rule of law. So what I want to do this morning is to give you an idea of what has happened in this matter, what this judgment says. And I-95.5 is taping this presentation, and they would have it replayed so that the members of the public would understand it, and the other members of the media who are here will obviously disseminate the information to the public. It would be noticed that the decision and actions which were challenged, in respect of which you, the municipal police officers, had to resort to court action in order to get justice, started under different administration. The facts show, however, that when this administration took office, the appeal of the government was pursued by the present Attorney General. The facts also show that in 2011, the Court of Appeal made an order requiring the government to make regulations in order to stop the injustice against municipal police officers. From 2011 to 2014, when the case was heard before the Privy Council, no regulations were made, although the Court of Appeal ordered the government to make those regulations within 6 months. The facts also show that after the Privy Council heard this appeal, the Attorney General, through his counsel, tried to satisfy the Privy Council that he was making efforts over the years to make the regulations, and the Privy Council found that there was no evidence to show this. The Attorney General then drafted regulations and sent to the Privy Council through his counsel. The Privy Council found that those regulations were deficient. The Attorney General then agreed through his counsel that the regulations were deficient and that he would have to introduce legislation in Parliament to correct those deficiencies. The Privy Council in this case and in its judgment raised an important issue, namely the Trinidad and Tobago Police Service operates with regulated service regulations, but the Municipal Police Service was not being so operated. This judgment must now cause the government and the police service to consider whether all police officers within the employ of the state ought to be regulated and ought to be treated equally. We cannot have police officers who perform coercive duties of arrest and affecting the enjoyment of property of individuals, and they are not operating under regulations. Further, we cannot have police officers experiencing ad hoc promotions on fairness, inequality of treatment, and arbitrariness. There is urgent action to have an overhaul of policing in Trinidad and Tobago and to consider how best to have the service regulated. This morning, 153 municipal police officers, in a landmark judgment delivered by the Privy Council, reversed the decision of the Court of Appeal and gave the municipal police officers victory in their lawsuit filed against the state. They won their appeal against the decision of the Court of Appeal, which decided that they were not entitled to an award of damages for the violation by the government of their constitutional rights. The Court of Appeal instead made a declaration that their rights were infringed by the government and also made an order compelling the government to make regulations which were required to be made in their favor under the Municipal Police Act and the Statutory Authorities Act. The High Court ordered the municipal police officers, had ordered the municipal police officers to get compensation, but the Court of Appeal dismissed this relief, and the High Court had dismissed the application of the municipal police officers to receive aggravated damages. The municipal police officers contended in their claim that the failure of the government to make these regulations deny them equality before the law and the protection of the law, which were guaranteed fundamental rights in the Constitution of Trinidad and Tobago. The Constitution provides that an aggrieved individual whose constitutional rights were infringed is entitled to obtain redress from the court, and that is exactly what powers the Privy Council exercise to grant you redress. I should mention here that the Privy Council, under the Constitution of Trinidad and Tobago, is the final court of appeal, and whatever orders it made, it has the same powers and authority as the Court of Appeal of Trinidad and Tobago, so they must be obeyed. The municipal police officers, in their constitutional claim in the High Court, obtained an order for compensatory damages, but the High Court refused to make an order for aggravated damages. The Court of Appeal decided that the High Court was wrong in that compensatory damages would be difficult to assess in the circumstances, and it instead made a declaration that their rights were violated. But it decided that the more appropriate order to make was compelling the government to make the regulations. The government, however, did not make the regulations. The Privy Council, in its judgment, decided, and it showed, that since 1876, in decided cases from then to now in the Commonwealth, damages, even though damages were difficult to assess and may sometimes be speculative, it did not prevent the court from assessing the damages. For example, you as municipal police officers, by not having the regulations made, you lost the chance of getting an order that you should have got the same pay as regular police officers, because up to 2000 you were getting the same pay as regular police officers, and you were getting 60% of the allowances, or most of the allowances, regular police officers got. And they had an exercise done in the police service, but none was done in your service, which meant that if there were regulations made, as they should have been made, then your association would have been able to go to the industrial court and get the industrial court to determine that you were so entitled. So what the Court of Appeal decided, that since we did not know what the industrial court would have decided, that is a risk, that is speculation, and you could not assess those damages. The Privy Council held that is wrong, because the court can consider what you were getting before 2000, and the court can consider what the police service is getting now. And therefore, if before 2000 you were getting the same salary and you were getting 60% of the allowances, the minimum on reasonable basis would be you should have got at least that. So that is what the Privy Council meant, that the fact that the Court of Appeal thought that this assessment may be difficult, it may be speculative, that is what the court is there for. That is what you make judges to do. They have to be able to assess. Also found that the Court of Appeal erred in law, and it set aside the orders of the Court of Appeal. The municipal police officers were awarded from the Privy Council today damages to be assessed in 4 categories for their violation of constitutional rights. The High Court would have to assess those damages pursuant to the order of the Privy Council in these 4 categories. First, the compensation for your losses. That is one category. So in other words, since 2000, what you would have lost in salary and allowances because they refused to make the regulations, but you were getting before the same salary and you were getting 60% of the allowances. So a court would have to have evidence, if it has to be assessed, what the police services, what regular police officers have been getting since 2000 and what allowances they were getting. And therefore, the difference of that you would be entitled to as of right based on the decision of the Privy Council. But that is not the end of the matter. The Privy Council decided that in addition to that award, you will get an additional award for aggravated damages. What does that mean? That means that because the conduct of the government allowed you to wait from 2000 to now and dilly-dallied, and the words they used, they had you in limbo, and you did not get your rights sorted out, the judge will have to take those factors into account, and the Privy Council directed that, and decide what award you should get as an extra for that. But that is not the end of the matter. That is what today might be one of the luckiest days in the lives of municipal police officers. You got another category. They said that there should be a special award to be assessed for damages for compensation to be paid to you for the failure of the government, this government, to obey the order of the Court of Appeal, which was made in 2011 and which gave them 6 months to make the regulation. So it was computed from 2012 for the government to have made those regulations, and those regulations have not been made. So compensatory damages, aggravated damages, and a special award for the behavior of keeping you in suspense and not giving you money. And what happens, the court in the cases before give you a sort of lump sum for those kind of things. But that's not the end of the matter. They went further. I don't know what you wanted. They went further. They decided that the longer the government takes to make the regulations and to allow you to have your representation, that if you could get your dispute settled by the industrial court, every day they do not make the regulations, they have to pay. So that is why they say any other award of damages which the judge may consider necessary, having regard to the facts and circumstances at the time of the assessment of damages. So if you read the judgment, they say, listen, courts do not normally compel a government to do something. because in effect government could always make an excuse. But judges expect and courts expect that when they make an order, the government obeys the order. But what the Privy Council did, what we could do, is that the courts could put a penalty that if you don't do it, what you have to pay. So they decided to do that. And when you read the judgment, which I will go to just now, I'll pick parts of it. When you read the judgment, you would see that the Privy Council made it clear that if the government was an ordinary person, there were many ways you could have gone against the person to compel the person to obey the order. But when the government or an attorney general does not obey an order of the court, it brings the administration of justice itself into disrepute, and it breaches the rule of law. So I'm trying to explain this to you, and the members of the public would have it explained when they listen to the rebroadcast. The municipal police officers contended that the effect of the failure of the government to make regulations under the Municipal Corporation Act and the Statutory Authorities Act meant that they could not access the Industrial Court for Justice if there were disputes between them and the government over pay and other terms and conditions of employment. Further, the failure of the government to make regulations permitted a system of promotion in the municipal police service which promoted unfairness, inequality of treatment, and arbitrariness. This is what the Privy Council found. And they went further in the judgment and said there was no denial by the state that this was not happening. So the evidence before the Privy Council and before the courts were by not making the regulations, you had unfairness, inequality of treatment, and arbitrariness. So what they are signaling, that if the government sits down and does not do anything about it, that is what they're going to be promoting in the municipal police service. Somebody said a lot of good prayers, boy, because the Privy Council found that the lamentable and long-standing state of affairs affected the constitutional rights of the municipal police officers to equality before the law and the protection of the law. The Privy Council found that the Trinidad and Tobago Police Service is governed by published police service regulations, but the municipal police officers were not. They also found that the municipal police officers suffered inordinate delay by the state in not addressing their grievances, and there was a combination of broken promises and stonewalling by the government. The Privy Council found that the failure of the government to obey the order of the Court of Appeal, which became effective in 2012 for the regulations to be made by the government, attracted a further award of damages. It found that the conduct of the government in not making the regulations amounted to a breach of the rule of law and to conduct on the part of the government which brings the system of justice itself into disrepute. Notwithstanding the order of the Court of Appeal to make the regulations, and that these regulations were not made at the time of the hearing of the matter before the Privy Council in October 2014. And you recall at that hearing, apart from my being there, you had representatives and they heard what I am telling you now, and some of the facts which I am telling you which didn't come out then, but was transpired after between the Attorney General and the Privy Council and the Council. You will hear what happened, and the public would know what happened. Efforts made by the Attorney General to make the regulations were sent to the Privy Council after the hearing before the Privy Council in October 2014. The documents produced showed that the regulations which were made by the Attorney General after the Privy Council heard the matter were deficient, and that he ultimately agreed that the deficiencies in the regulations would have to be corrected by Parliament, paragraphs 49 to 52 of the judgment. But I will give you an idea of what happened. At the hearing before the Privy Council in October 2014, Counsel for the Attorney General informed the Privy Council that steps were being taken to meet the regulatory concerns of the municipal police officers. The Privy Council, however, found, they stated, in the judgment it is stated, that there was no evidence before the Privy Council that the government was belatedly complying with the order of the Court of Appeal. So it rejected what the Attorney General said. After the hearing before the Privy Council in October 2014, the Attorney General, through his counsel, submitted a chronology in an attempt to show the efforts made by him and the government to make the regulations. The Privy Council found that none of the material put before it by the Attorney General justified the unconscionable delay by the government to make the regulation. If you read the postscript of the judgment, you'll see what I'm saying. Further, 11 days after the hearing of the appeal in October 2014, Counsel for the Attorney General informed the Privy Council that the government enacted a municipal police regulation. So he's saying, we made regulation, and he sent a copy. The Privy Council response was that the regulations enacted were defective, and the Privy Council put those questions to Counsel for the Attorney General. Obviously, at that stage, it looks like the Attorney General gave up. In a further note by Counsel for the Attorney General to the Privy Council, the Attorney General tried to use the Interpretation Act of Trinidad and Tobago to convince the Privy Council that there were no deficiencies in the regulation, which were drafted by the Office of the Attorney General and sent to the Privy Council. The Privy Council obviously did not agree with it, and the Attorney General, through his counsel, ultimately admitted to the Privy Council the deficiencies in the regulations which he made and which were drafted, and that they would have to be corrected with further legislation of some kind in order to cure those deficiencies in the regulation. So at the present time, they made no regulations. The court ordered them to make. They made none. We went to the Privy Council. They had none. They told the Privy Council that they were trying to make regulations. The Privy Council found that there was no evidence of that. And then they made regulations, but the Privy Council said that those regulations were deficient. So as it stands, there are no regulations. And your money keep on accruing. Now, what I did in this press release and this statement, I wouldn't read all of this, but I will just tell you what I did. I put for the members of the media to understand what Section 60 of the Municipal Corporations Act and the Statutory Authorities Act required. Basically, if I would summarize it, what these two acts required was that in respect of the Municipal Corporations Act, the act required for the government to make regulations, and those regulations were for many things, but it included regulations for promotion in order to have a proper system of regulation. Because in the police service, you have a system of regulation. In the municipal police officer, it's done ad hoc, unfairly, it could be unequal treatment. So what the Municipal Police Act anticipated, that you'll have the same kind of regime, a parallel regime in the municipal police service. Under Section 60 of the Act, it also gave the Statutory Service Commission to deem whatever, in the meantime, to deem whatever regulation which applied to the police officers to make them apply to municipal police officers. So those are some of the regulations which were not made for you. In the Statutory Authorities Act, there were also a requirement to make regulation. Now, those regulations have to do for the conditions which must be satisfied by your association in order to have it as what is called a bargaining power. Because right now, although your association exists, since no regulations were made, you did not have any teeth. You were like a dragon without fire. You were like a tiger without teeth. So because you couldn't do anything. If the regulations were made, you could have then triggered the process for you to have the industrial court determine what your pay should be. So in other words, it anticipated that you would have a similar process as a special tribunal in the regular police service to have the industrial court, which order of the industrial court would have been final. So because of the non-making of the regulations, you were denied those rights. And that is why they say you were denied the protection of the law. Under the heading Chronology of Claim filed by the Municipal Police Officers, I have placed this to give a sort of history of the matter to show what was filed so that the members of the media, when they read it, they could understand the injustice that you suffered. And I would just like to mention that before you filed your claim, you would remember we wrote letters. You had discussion. You tried everything in the book. The only thing you didn't do was to bend down and kneel and beg them to sort you out. And remember, we didn't even get a reply when we wrote the letter. We didn't even get a reply. So you, as police officers, were driven to file a court action. Now we know that this court action was filed under a different administration. So I'm not blaming this administration for everything. What I'm saying, it was filed under a different administration and the process continued. What happened, however, is that in 2011, when the matter came to a head-on and the Court of Appeal decided that I am not giving the municipal officers, police officers, any damages, I'm only making a declaration. But government, I want you to make these regulations within 6 months. The fact of the matter is that notwithstanding all the history, this government has not made it, and up to today has not made it. So basically, that is a summary or an explanation of the judgment. In closing, and before I invite questions from both members of the media and police officers who want to ask, I want to tell you this has not been an easy battle. It has been long. And I think it's about 12 years now that we are fighting this battle. I think shortly after I was no longer Attorney General, you all came to me, and I told you when you came to me that this was an injustice. And you remember I had just left office when I was the Attorney General with the then Minister of National Security, who persuaded Cabinet to absorb Special Reserve Police officers into the police service. So when you came to me, it was something that I knew about. I knew about the injustice. And probably if I had continued to be Attorney General, we would not have had to go to the Privy Council. But such is life. We are here. And I must congratulate you for having the determination, the courage, and the confidence in me that ultimately you would have got justice. And we had a very difficult time because we had a sort of half victory in the High Court. And when we went to the Court of Appeal, we in effect got no victory or a small victory because they said you were not entitled to whatever happened in the past, and it was sufficient for you merely to get the regulations made. And we had to go all the way to London. You had to send some of your officers there because it's a lot of anxiety. But I am happy that I was, in this case, from the beginning to the end. It would please me to know that not only that you got justice, but this is another landmark decision in the development of constitutional law, not only in Trinidad and Tobago, not only in the Caribbean, in the Commonwealth. This case would be in the law reports of all major law reports in the Commonwealth. It will be referred to, you will see it, it will be commented by professors, by university lecturers, law students will have to know about this case. And why it is special is because there is now a new dimension for damages in constitutional law, which would send a signal to governments, not only the government of Trinidad and Tobago, to governments throughout the Commonwealth, that they should not dilly-dally with the rights of officers. And as you know, over the last 9 months, I have had the cause to call similar press conferences like this because you had similar cases of injustice which were corrected by the Privy Council, some in private law, some in public law. In the month of December, we had a former Prime Minister of St. Vincent and the Grenadines, Sir James Mitchell. He lost in the High Court, he lost in the Court of Appeal, he lost a few times in the local courts, and he won in a matter of a few weeks in the Privy Council. So I apologize if you had to suffer so much, but thank God we have been able to get what you deserve. Thank you very much. Any questions?
Mr. Maharaj, money here. what time frame do you anticipate that the officers can say, I'm going to the bank to collect that money?
Well, that's a very good question. The government has an option. The option would be at this stage, what the government can do, the government can say, well, listen, let me look at this and let me make an offer and let me try to settle it. Because this is not an ordinary case. These are police officers who are part and parcel of the machinery of the state. They perform an important function. They perform the function of preserving law and order. Only last night, when I listened to President Obama in his speech, the address to the State of the Nation, if you realize one of the first things he did was to pay tribute to the army and to the police and etc. Because you have to recognize that if you are doing an injustice to police officers, how do you expect them to fight crime? So I would think that having read that judgment, that the government has a responsibility to decide to make an offer to resolve this matter. If they do not make an offer to resolve this matter, their money is guaranteed. It is not like a company will go bust. It will take some time for the assessment of damages to take place before the High Court. But what can happen, we can ask for an interim payment because there is no question of liability. Liability has been determined. So if a judge sees that each municipal police officer will be entitled to $3 million, let's just assume $3 million, we could ask the judge to make an order for the government to pay $1 million on account until the matter is determined. Because this is not a case, there are rules for that. This is not a case where the courts have to decide whether the government is liable. The final court has decided that the government has to pay. And they have given you the sort of criteria to be applied in assessing those damages. And that is how they normally do it, because the Privy Council itself doesn't assess the damages. Direct the local court to do it. So I cannot answer your question by saying 2 months, 3 months. But what I could say is that if the government continues its stubbornness not to resolve this matter, a lot of taxpayers' monies will be paid to these people, not only for what is due to them, but on interest. Every day interest on this money would accrue. Every day. So let's see what they say. I would invite you to contact the Attorney General and say, this is what the Privy Council say. Are you going to retain all these lawyers to fight this again? They might pay more money in paying the lawyers than in paying the people.
Mr. Maharaj, what do you think is a reasonable offer?
Okay, I can't give you the figure, but I'll give you an idea. I'll give you an idea how it will be computed. A court would have to consider that from the year 2000, whatever regular police officers got as their salary and whatever municipal police officers got, a court will have to consider that difference. A court will also have to consider that they were entitled, at that time, it was recognized that they're entitled to 60% of their allowances. So they will have to see what municipal police officers lost. Then the judge would have to consider what rate of interest be ordering in favor of these people who have been denied their money from 2000 to now. Then the court would then have to consider the second award, aggravated damages. So the court would have to consider that for 15 years, these people have been denied. And even if the court decide to give them $1,000 a month, that's $12,000 a year. Check that for 15 years. That's a lot of money. Then there is another award, which will be a very big award. This is where the government refused to make the regulation, although ordered by the court. That will at least be a similar amount that the award made for aggravated damages, if not more. And then, if this matter continues and the government doesn't settle or doesn't deposit money into court to pay these people a reasonable amount, the court could then consider the behavior of the government from today to the time this matter is assessed and make a special award for that. So you're talking in terms of millions of dollars. This is a big claim. This is a big claim. And I don't want to make things, but it's my duty to say, although this didn't cover the municipal police officers who didn't perform part of the action, it doesn't mean to say that the government is not liable to them, because those municipal police officers can now file an action and the government would not be able to contest it, because it is something known in law as res judicata. So the matter has already been decided. So that is why any Prime Minister or any Attorney General who have the public interest at heart, this is more important than putting on a Santa Claus outfit and delivering toys. This is more important than all the ads government working for you. If government really working for you tonight or tomorrow, the Prime Minister should get a report on this case and she should be able to make a decision within days of what they're going to do with it. They must tell these police officers, we give you a commitment that we are going to try and resolve this matter. We are going to have discussions with you to try and see what we can agree on. And if they feel that that is a reasonable amount and a fair amount, they will be entitled to deposit that money into court if these people refuse to accept it. And if they're right, then the court will order that and order them to pay costs from that day. If it's not a reasonable award, however, they could take that, but also fight the case, or they could go and get an interim award. That is why I think what the Privy Council did here is to, remember they have been deciding these cases over the years, and they decide that redress in section 14 of the Constitution has to be meaningful. It can't be a tokenism, it can't be cosmetic. And if a government decides to violate your right, the court has a duty to give you effective redress. So I hope I have been able to explain it. I do not want to make it appear as though the police officers should be combative in this. They have not been combative at all. They have always taken the position, and they are here, that they would prefer to resolve this matter. But obviously resolve it in accordance with justice. These police officers, in my view, would be prepared to consider resolving it at this stage even. They serve the people of Trinidad and Tobago. They don't want to fight a government, much less go to court, and much less to maintain a battle, a legal battle in court. But if a government does not give people justice that is due to them, the government itself cannot pass the test of being just. So this is how I see it. And that is why I called this press conference today, because this case has plenty of implications. If I were the Attorney General, I would have advised the Prime Minister that we have to look at all police officers who perform police functions. Special Reserve, Estate Constable, Municipal Police, all of them. And we have to have all of them being treated equally in relation to what duties they do. And therefore, you can't have some of them doing police work, but not part of the police service. You can't have SRP doing police work, but not part of the police service. You can't have estate constables doing police work, working with the police, but not part of the police service. Because if you as a government sending a signal that you could be unequal to your police officers, who are really the heart of your defense and law and order in Trinidad and Tobago, it doesn't send the right signal. So this needs looking at seriously, and it needs to compensate these people. They have suffered a grave injustice, a very grave injustice. Not easy to know that you're working and people doing the same work that you're doing, but they're getting better treatment.
If this rolls over into the election and a new government is formed, what is their position?
The new government is bound by the decision of the Privy Council. This has nothing to do with a change of government. As a matter of fact, a decision of the court binds government, whichever government it is, binds the state. And a new government cannot relitigate this matter. A new government will have to accept the order of the court. There is continuity in government. There may be changes of the people who comprise the government. That is why, bring me to tell you something, that is why what members of a government do, they may long go on, they may long be away from there, but whatever they do can cause a lot of prejudice if monies were spent recklessly, because then the taxpayer has to pay for it. It doesn't mean that the individual have to pay for it. The government has to pay for it. Any questions?
Not a question, Mr. Maharaj, but that's what I mean to state that when I came and I saw all the officers here, I thought they came for you finally to talk out against the government.
Well, you can never tell. You can never tell. They might come for me after. The only thing is that that happened before, you know. But if you're doing this kind of work and you're a lawyer, you have to stand up for people, and you must be prepared to face the consequences, whatever they are. And if in the pursuit of your legal profession you are harassed, or you are victimized, and etc., you are wrongfully detained and imprisoned, that is a price that you have to pay. I have gone through that, and I have fought many legal battles, and I know that the battles that you fight in these, no matter what you expect, any event, but I'm prepared to deal with it. I don't have anything to hide. So if they want to come for me, come. I'm sure I could get some lawyer here who is one of the police officers to defend me. Anything else, ladies and gentlemen? Okay. Well, I don't know if you want to ask the head of Inspector Lewis is the head of the Municipal Police Association. So I don't know if you want, Mr. Are you prepared to answer any questions? Yeah, he'll be prepared to answer any questions.
You could just tell us his feelings, how you feel about his judgment.
Well, of course. Let him use the mic.
You want to come here?
The results of the Privy Council.
Introduce yourself, please.
My name is Dr. Lewis, Police Inspector with the Municipal Police. This matter this morning brought on a certain high degree of happiness among the colleagues, officers of the Municipal Police. However, it must be noted that we have not seen this as a victory against the state or employer, but rather a victory for the injustice we have suffered over the years. We, from the very early stage, never intended that we should enter into a battle with our employer. And we wished from then to now that this never happened. However, having regard to all the circumstances and the fact that we have taken all steps to rectify the situation that left us in a situation where it was not solved, we had to resort to the legal avenues. But this is not what we wanted. And we continue to say to our employer that we are willing to serve our country in accordance with the oath of office. Notwithstanding what has been done, we are the citizens of this country, we are part of the security machinery, and we perform our role at the highest level. At the same time, though, we are asking our employer that please sit with us and let us see if we can solve this matter once and for all. Especially as it relates to the regulation, the making of the new regulation. We saw some deficiencies in it, and we want to have some input so that we don't want to have an adversarial relationship where we're going back to the court to fight against our employer. My colleagues who went through this battle, I want to thank, first of all, the Almighty God for seeing us through this. We know that He is just, and we also know that He pours rain on the just and the unjust, and He'll see us through our struggles.
Amen.
Secondly, I want to thank Mr. Maharaj. I remember the very first day I walked in here, and we never intended to forge a relationship in terms of law, but rather we came because we wanted somebody to go to, and we had nobody. And Mr. Maharaj came up, and we came, and he willingly opened his door to us. He did enter into discussion, and he guided us. Even at that time, Mr. Maharaj never intended us to take the matter to court. He had asked us to approach our employer again, which did not work. So I want to thank Mr. Maharaj, and I want to thank the international lawyers, Mr. Privy Council, and Mr. Robert Strand, the other person, and the other people internationally who work alongside our case. Finally, I want to thank the government. One might wonder why I'm saying thanking the government. Because the role they played brought us through a route that now recognize, when we cannot recognize, there is a need for us to come together, and the country must see the importance of our role as far as it relates to law enforcement. Where there were doubts in recognizing the roles and functions of municipal police, it is now written in the annex of law. So I'm thankful for the government even to that point. Thank you all again.